just pick up on 3 points, outstanding points which arise from this morning. Firstly, can we hand up a copy of the agreed statement of facts which was before the FTT, and that is in substantially the same form. I think the only difference is this includes the company numbers, but in all other respects it's the same. And then in the other item you asked for was closure notices, which are in the appeal bundle. Apologies. They're in tab 18. So you'll find those there.
Thank you very much.
Thank you. And thirdly, you asked me whether there are examples of the court expressly departing from a previous decision, and there are. And I'm pleased to say that one of them is in the bundle. It's the Merck judgment. We looked at the AGO. But you'll find the Merck judgment behind tab 33, and it's, if you take a look at paragraphs 27 to 29, 33, 43 and 50, and you can see that that's what the court was doing there. And then I think the only other outstanding matter is the revenues comparative analysis, and I think they're going to email it overnight.
Yes, that was what we're proposing to do, and then we'll perhaps bring copies as well if you
All
want.
right, lovely.
Yeah.
Thank you. Yes, Mr. Yode.
I was going to start, my lady, with Marks and Spencer, which is the origin of all of this. I think it's fair to say it's in volume 2 of the authorities, behind tab 38. I'm looking at the judgment of the court. I don't think anyone ever looks at the Advocate General's opinion, not because it's not a brilliant opinion, but because it went off on a different tangent completely from the way the court decided the case. So this concerns the UK group relief provisions, and Marks and Spencer's, who had subsidiaries in a number of European countries, including in particular France, Germany and Belgium, who made losses. I think in France, particularly large losses, and they wish to group relieve them against the profits of the UK parent company, and of course the UK provisions prohibited that because you could only surrender losses from a UK resident company, so it was quite straightforwardly prohibited by the UK provisions. And the argument was that that breached the right of establishment, freedom of establishment of the UK parent. And the court identified a difference in treatment, because clearly there was a difference in treatment between the UK subsidiary and a European subsidiary. And it then went on to consider justification, and that's the important part. And it begins at paragraph 38, which is on page 427. And I was wanting to pick it up particularly at paragraph 41, where the court said, in order to ascertain whether such a restriction is justified, it's necessary to consider what the consequences would be if an advantage such as that at issue in the main proceedings were to be extended unconditionally. So what are the problems that would arise if in fact the UK simply allowed all non-resident companies to surrender their losses to UK parent? And then on that point, the United Kingdom and other member states put forward 3 factors to justify the restriction. The first is what is referred to as the balanced allocation of taxing rights. The second is double use of losses, and the third is the risk of tax avoidance. Now, the balanced allocation of taxing rights, broadly that says that a state ought to be able to tax the profits which arise in that state. The problem with allowing a surrender of losses from, say, a French subsidiary is that you would then be reducing the UK tax base by the losses which were generated outside the UK in France. And of course, the UK doesn't exercise any taxing power over the profits of a French company. So allowing that surrender would upset the balanced allocation of taxing rights, because it would allow, in a sense, effectively losses from other countries to be imported into the UK, and so that the UK would not be able to tax all of the profits generated in its territory. So that's the balanced allocation, and that is the justification, you will recall, that the Advocate General in Phillips thought was the most important.
She subsumes everything else.
She subsumes
pretty much into it, which is one of the puzzling features of her analysis.
In that case, exactly.
In that case, yes.
Exactly, my lord. I hope to show you that isn't the case. That doesn't happen in any other case, apart from Phillips. And indeed, in a subsequent case after NN, the same Advocate General, in fact, appears to treat double use of losses as a separate justification. We'll come on to that. She may have seen the error of her ways.
But she didn't say so.
No, of course not.
She didn't say so, no.
But to be fair, and she's always, her opinions are nearly always very illuminating and
absolutely,
and great value.
Yeah, and I think you'll find that her general approach is that she's not very keen on the Marks and Spencer's no possibilities test. I think she would rather it was got rid of, and she said it a number of times, including in one of the cases that we'll look at. But the court have never taken that up. What they've in fact done is to continually contract it so that it only applies in very, very limited circumstances, I think, as my learned friend suggested. Then the court goes on to consider these justifications. Paragraph 44, it says that must be, you cannot plead a reduction in tax revenue on its own as a justification. But they say in paragraph 45, the preservation of the allocation of the power to impose taxes between member states might make it necessary to apply to the economic activities of companies established in one of those states only the tax rules of that state in respect of both profits and losses. In effect, to give companies the option to have their losses taken into account in the member state in which they were established or in another member state would significantly jeopardise a balanced allocation of the power to impose taxes between member states, as the taxable basis would be increased in the first state and reduced in the second to the extent of the losses transferred. And then, very importantly, we'll see this repeated in a number of cases, as regards the second justification relating to the danger that losses would be used twice, it must be accepted that member states must be able to prevent that from occurring. And then 48, such a danger does in fact exist if group relief is extended to the losses of non-resident subsidiaries. It is avoided by a rule which precludes relief in respect of those losses. And then they deal with the third justification, where they essentially say there is a scope for tax avoidance if you could do this, because you could transfer the losses from a country with a low rate of tax to a country with a state with a high rate of tax. And they make the point in paragraph 50, excluding group relief incurred by non-resident subsidiaries prevents such practices may be inspired by the realisation the rates of tax applied in various member states vary significantly. Then they go on to say, in the light of these three justifications taken together, it must be observed that restrictive provisions such as those at issue in the main proceedings pursue legitimate objectives. You'll notice objectives which are compatible with the treaty and constitute overriding reasons in the public interest, and they're apt to ensure the attainment of those objectives. So we would submit, and we'll see how this developed over the case law, that what the court was saying is that there are these three justifications which happen to exist in this case, and they justify the measure. What they were not saying was, you have to have these three justifications in order to justify any measure, or indeed, you have to have two of these justifications.
And still less that one of them trumps all the others.
That one of them trumps all the others, yes, exactly. Yes, that's certainly not what they were saying in this case. And then
But their decision is made on the basis of the three justifications taken together.
it is, yes. So I think it's fair to say at that stage of the development of the case law, it wouldn't have been clear, and we can see that in later cases where the court, I think national courts refer questions asking, can you have only two of them? Can you have, etc. It wouldn't have been absolutely clear. The court could have gone down a line and said, well, you need all three justifications, otherwise it cannot justify. But that's not the line that they took, in fact. But they leave it open. I think my point is that it's open to the interpretation that these are three separate, self-standing justifications. And it's really only the words taken together that suggest otherwise.
Okay, but you say in any event later cases show that they're self-standing.
Absolutely, and well, obviously culminating in NN and later cases. Yeah. And then we have the part of the judgment that has caused the most problems, paragraph 55. I think Advocate General Cocotte has referred to this in one of her opinions. That this creates chaos and confusion, and a great deal of litigation, certainly in the UK and I think in other countries as well, as to what it means. So this is where we get to the question that this is proportionality that they're dealing with now. Because they say in paragraph 53, the court must ascertain whether the restrictive measure goes beyond what is necessary to obtain the objectives pursued. And then they recite arguments by the claimant and the commission that there could have been less restrictive measures, including dealing with, well, you can read it yourself, but it includes conditionality on the subsequent profits being incorporated in the taxable profits of the company, which is a sort of clawback, I think. It's rather like the way the Dutch system works, in fact. The losses are subsequently incorporated. But then they go on, in paragraph 55, they say the restrictive measure at issue in the main proceedings goes beyond what is necessary to attain the essential part of the objectives pursued, where the non-resident subsidiary has exhausted the possibilities available in its state of residence of having the losses taken into account for the accounting period concerned, and also for previous accounting periods, if necessary by transferring these losses to a third party, or by offsetting the losses against the profits made by the subsidiary in previous periods, and there is no possibility for the foreign subsidiary's losses to be taken into account for future periods, either by the subsidiary itself or by a third party, in particular where the subsidiary has been sold to the third party. And in fact, that was the case in one of the subsidiaries in Marks and Spencer's. The French subsidiary had been sold along with the losses. And we would say, first, on the face of it, the situation that's being envisaged there is a situation where the non-resident subsidiary simply cannot use the losses for whatever reason. It's impossible for them to use them. However, it would still, of course, upset the balanced allocation of taxing rights, because it would still result in losses that were generated in France, reducing the tax base in the UK. But it appears that would be acceptable because the losses in France could not be used anywhere else. So we're only looking at one use of losses. So it does look on the face of it as though the double use of losses is quite an important aspect of all of this.
Well, that's Michelle's point, isn't it, about effectively you treat the loss as the loss of the parent company.
Well,
or not.
Or not. Well, I'm making a simpler point, I think,
Yeah.
my lady. I'm simply saying there isn't scope for the double use of losses.
Yes,
If
no,
they
I
cannot be used in
understand
one
that,
of
but it also overlaps with, I think, the point she was making.
Yes.
Yeah.
Yeah.
And in a sense, there's a risk of being overcomplicated here, isn't there? I mean, double use of losses by the same taxpayer in respect of the same period is just pretty much self-evidently objectionable.
Yes.
It's like pure double taxation. I mean, it's the opposite of that.
Yes. But in this case, it would be by the same group.
By the same group.
But certainly, the same losses are being used.
I mean, the whole purpose of group relief is to treat the group as a kind of notional person, I suppose.
Yes.
For
Exactly.
most purposes.
Exactly. Yes.
So you can't have a double dip. I mean, it's just common sense, isn't it? That's good.
Yes. Well, that's
Perhaps I know it's not a very scientific explanation.
no. But I would suggest that is the thinking behind the court's let out in paragraph 55. That it's based on the fact that the losses have to be used somewhere else, and in fact that's what the Advocate General says in Bevola, in the passage my learned friend took you to. That was that definitive losses must be used somewhere, must be available to be used somewhere. Definitive meaning they can't be used in the other state. That's the term that's used. Has become used in the case law. Essentially, it means that they've closed up business. They've got no income at all, and there's no prospect of any income. There cannot be any income. In fact, essentially, it only really applies where the company is wound up. I think that's pretty much the circumstance now. Looking at the case law on this. Um,
I mean, even a company that's been wound up in certain circumstances can be restored to the register.
Yes, they can. Yes, I think that was something that, in fact, you may laugh, but that was something that was raised in the Marks and Spencer's litigation.
Well, I'm not surprised.
I think there was expert evidence, in fact, my recollection, on whether companies in certain other countries could be restored.
Well, if you're looking at legal possibilities, I mean, that is a possibility, is it not, in most cases. So one has to, one mustn't go too far, lose touch with the ground too much.
Yes, but certainly it's clear from the case law now that if the company has any income at all, then it doesn't qualify under this, because it can use losses, even small. You see that, but the court has gone quite far. And they also have said that if the reason you can't use them is because of a legal provision in the other country, that doesn't count either. So because then you are effectively, the UK is then effectively being governed by the legal provisions in France or Germany. So if France and Germany says you can't use the losses for some reason under their law, that doesn't pass the test of no possibilities. It's not a definitive loss. And we'll see that in a case called the EC Commission in the UK, which was the case that infraction proceedings against the UK.
Are you taking us to that?
I'll take you to that, yeah, in relation to the new legislation that was passed after Marks and Spencer.
That's not the one we were taking to the correspondence about this morning, is it?
No.
That was a threatened infraction proceeding.
That was a threatened infraction proceedings in relation to these provisions.
These provisions, sorry.
The infraction proceedings that were in the Commission in the UK were because the UK legislation said that you look at the question of no possibility at the end of the accounting period in which the losses arose. And the Commission said that was contrary to Marks and Spencer's. It turned out it wasn't in the end. But the court discussed various parts of the test and that. So can I then take you briefly to the next case is OI, one of the many OI cases, OI AA, which is in tab 44 of the same bundle. I'm only taking you to this because to show you that in this case double use of losses didn't arise. The reason I'm doing that is because when we come to Phillips, you may have seen this already. I don't think this is a passage my learned friend took you to, but the Advocate General's reasoning in relation to justification appears to be looking at two cases. One of them, I think, is this case and another case, both of which the balanced allocation of taxing rights was one of the justifications that were in play. And she said, therefore, I deduce from that you have to have the balanced allocation of taxing rights. Now, we would say that's not good reasoning. But I just wanted to show you this case. It's a Finnish case. The parent, a parent which had at least 90% of the shares in the subsidiary, if that happened, the subsidiary could make a financial transfer to the parent, and the subsidiary got a deduction from its taxable income, and the parent had it added to its income. I think the idea there was the parent might have losses, for instance, and this was a way of making use of the losses.
It's a form of
group relief. Yes. However, both companies had to be established in Finland, and so there was an argument about that. But the important point to note about this is that it doesn't concern it doesn't actually directly concern losses. And that's the point that was made by the court. I can just take you there. They were discussing justification on page 526. And in fact, they concluded that it was justified by the balanced allocation justification and the tax avoidance. However, in this discussion, you'll see at paragraph 57, the reason that double deduction of losses wasn't an issue. The risk that losses might be used twice is sufficient to point out the Finnish system of intragroup financial transfers does not concern the deductibility of losses. So they didn't think
that's Falk and sweet.
that you could end up using losses twice. I suppose that's probably right, because there would only be one set of losses, which would be the losses in the, theoretically the losses in the parent company.
Sorry, the financial transfer was a transfer of income, was it, rather than deductions?
I understand it was an actual transfer of something, funds or something, yes. But it
increased income in the parent.
It was then, yes, exactly, increased income in the parent and they give a deduction to the subsidiary.
Okay, so rather than surrendering losses, it's effectively pushing profits.
Pushing profits, exactly.
Up.
Yeah.
Okay.
Yeah. And that's why the court didn't think that the double use of losses was relevant in that case. Whether it was right or not, but that was the reason anyway. The next case is Little Belgium, which is the next over. It's tab 46. I'm going to take you to the court judgment. The Advocate General's behind paragraph 45. This is the opposite kind of case. A German limited partnership had a PE in Luxembourg. The PE incurred a loss, and the German limited partnership tried to deduct it from its profits. And this was refused because the profits of the PE were exempt from tax in Germany under the German-Luxembourg double tax treaty. So this is an example. There are a number of ways in which, or two main ways in which double tax relief can be given in this situation. One is to say, as they do, I think, in the Dutch-UK treaty, essentially that it can be taxed, that the profits of the PE can be taxed in the state of residence of the PE, but also in the other state, and then you give credit relief if there's double taxation. The other way is to say it can only be taxed in the state of the PE, and it is exempt essentially in the other state, and that's the system that they had in the German. Seems in the German-Luxembourg treaty. And they looked at Marks and Spencer and the justifications there, and if you could just pick it up at paragraph 34 in page 547. And continue on, sorry, to paragraph 42, if you can. And the two justifications here were, as you'll have seen, the balanced allocation of taxing rights and double use of losses. And I would particularly draw attention to, well, paragraph 35, which repeats what was said in Marks and Spencer's. The court has accepted that member states must be able to prevent such a danger, that is, double use of losses. And then paragraph 37. Consequently, the two justifications put forward must each be considered as being capable of justifying a restriction on the freedom of establishment.
Is paragraph 41 consistent with that? Paragraph 41 appears to suggest that you need two.
Well...
Or am I just being silly?
I think what they go on to then discuss is this question that's been raised as to whether... so you'll see in paragraph 38, the National Court asked whether you needed to include prevent the risk of tax avoidance.
Yeah.
And they said, no, you don't have to have that in it.
The answer
they're answering the question, well, do you have to have the risk of tax avoidance in amongst the justifications for it to be successful?
I mean, the examples given in 41 and 42 both say 2 out of 3 will do, basically.
Yes.
Don't they?
But the suggestion in 37
but just one alone
is that one
enough.
alone. That's the point of my question. So
yes, I think that 38 to 42, I would submit, are answering a specific question.
Right.
Which is being asked by the National Court. Because if you then say the National Court asks, however, whether the justification set out at 44 to 50 of the judgment Marks and Spencer's, which include the need to prevent risk of tax consequences being cumulative, or whether the existence of only one of those factors is sufficient.
Well, it seems they're really giving a kind of half answer. They're saying they don't have to be cumulative, and 2 out of 3 will do, but it seems to leave open whether one by itself is enough.
Yeah.
Yes, except that what they said in 37.
Well, that's why I don't really.
Each of them.
I'm trying to interpreting it as a whole.
Well, the answer may be. I think the answer may be that they are saying in 37 that each are capable of justifying the restriction, but they're only being asked thereafter whether 2 out of 3 will do, as your lordship says, and they've answered that.
Right.
It does say justified in the light of 2 of the factors. It's not
Well-
necessarily saying they have to be two.
I mean, if just one was enough,
Why do they
simple
need
to
all
say
of
so.
this?
Yes,
in
well,
which
you
case you don't need to bother
Don't
whether
need
it's
any
two.
of this.
Quite often,
Say-
that's a question a point that can be made about European court judgments, I'm afraid.
Well, absolutely, yes.
Yes,
Because you could just stop. Anyway.
they could have stopped. Yes, they could have stopped at 37, but they were actually specifically asked that question. That's what we had to answer it.
But it's just that the particularity of the answer seems to detract slightly from the generality of. Anyway.
Yes, yeah.
Right.
And the last case, I think, in that bundle is K, which is at tab 54. I think it's actually the next one.
Going to be another bundle.
Yes, I think it's in tab 54. Oh, sorry. Oh yes, bundle 3, sorry. It's tab 54. In this case, the mysterious K made a loss from the sale of movable property in France. He or she was, in fact, fully liable to tax in Finland. K wanted to deduct the loss from the sale in France from gains he made in Finland on the sale of shares. Finnish law didn't allow this because the immovable property was situated in France. And K argued that the loss had become definitive because he had no more property in France. He said, and therefore he couldn't use it in France. And if we just look at how the court dealt with this, there was a difference in treatment. And if we turn up to paragraph 48 of the judgment, as far as concerns the possibility of deducting losses sustained on the sale of movable property cannot be justified by difference in situation where the property is situated. And then they continue to consider whether it can be justified by overriding reasons in the public interest, which relate to the need to safeguard the balance allocation of power to impose taxes and the need to prevent losses being taken into account twice. And then they go on to consider the balance allocation. And they say in paragraph 51, the objective, as the court has already stated, is designed inter alia to safeguard the symmetry between the right to tax profits and the right to deduct losses. See Little in Belgium and Phillips. In particular, in order to prevent taxpayers from choosing freely the member state in which profits to be taxed or losses are to be deducted. And that was the case here, although I think it's true to say that the losses would only be deducted once on the assumptions that were being made. And then the conclusion at 55, that being so, the Advocate General in essence states in point 40 of his opinion, the refusal to allow deduction of losses arising from the sale of movable property situated in France permits the symmetry between the right to tax profits and the right to deduct losses to be safeguarded. The measure also contributes to the objective of ensuring a balanced allocation of the power to impose taxes. And then they turn to double deduction of losses. And they do say, in paragraph 56, they repeat what we've seen already in Marks and Spencer's and in Lidl. Member states must be able to prevent that danger. However, they say in circumstances such as those underlying the dispute in the main proceedings, there appears to be no danger of a taxpayer deducting the same loss twice. And then they go on to consider tax avoidance and fiscal cohesion. And they consider proportionality beginning at paragraph 72. where they consider it in the context of the Marks and Spencers. You see in paragraph 75, they are describing Marks and Spencers. And then they say, however, in a situation such as that in issue in the main proceedings, a taxpayer such as K cannot be regarded, irrespective of the considerations of facts set out by the referring court, to have exhausted the possibility available in the member state in which the property is situated, having the losses taken into account. 77. Since the member state in which the property is situated does not provide for the possibility of losses incurred on the sale of the property being taken into account, such a possibility has never existed. So that's an aspect of the point I was making earlier. That if the reason that you can't take it, can't use the losses in the other state is because the other state doesn't allow you to, under its law, then that doesn't bring you within the no possibilities test. And they explain that in 78. In such circumstances, if it were to accept that the member state in which the taxpayer resides must nevertheless allow losses on a movable property to be deducted from taxable profits in that member state, that would effectively oblige the latter to bear the adverse consequences arising from the application of the tax legislation adopted by the member state in which the property is situated. So if France doesn't allow you to use the losses, that's their problem. It's not a problem for other member states. As a result, they weren't able to. The legislation was therefore justified and proportionate.
And that's just recognising the fact that the EU doesn't have any harmonised system of direct taxation.
Yes, it does. Yes, exactly. But it does seem strange initially. You might have thought that the one case where you would be able to use the losses would be where the other state didn't allow you to use them.
Indeed.
But that seems to be the case you can't. And then the next case, the next case in the bundle is it's now AOI rather than AA. This is AOI. This concerned a resident in Sweden. Sorry, a resident company. Its parent was resident in Finland. So B was resident in Sweden, A was resident in Finland, its parent. B made losses and closed its outlets in Sweden. A planned to merge with B. If B had also been a Finnish company, then its losses would have passed to A on the merger. That was not the case where B was Swedish under Finnish law. A applied for an advance decision on whether B's losses would transfer. So none of this had actually happened, but they were bringing a case for an advance ruling, and it went to the European Court as to whether this was acceptable. And the justifications are dealt with. Beginning at paragraph 40. Where they discuss, first of all, balanced allocation. At paragraphs 41 to 43. And then paragraph 44, they say, as regards next to risk that losses will be used twice, such a risk does indeed exist if, in connection with a merger such as that issued in the main proceedings, the parent company established in another member state enjoys the possibility of deducting from its taxable income the losses of the merged subsidiary. That risk is averted by a rule which excludes that possibility. And then there is a discussion about proportionality. Sorry, it was justified by the factors taken together, you'll see in paragraph 46. However, they had to consider proportionality. And perhaps if you just read paragraph...
So that, again, that's taking justifying factors together.
Taken together, yes, exactly.
So, and which? Double deduction?
That was double deduction and ballast allocation. And tax avoidance. So
So
I
it's
think
all
all
three.
of them. All of them, yeah. you just want to read paragraphs 49 to 54. That summarises a number of the different ways in which you might fail to meet the no possibilities test. So you can see from paragraph 54, for the National Court to determine whether A has in fact proved that B has exhausted all the possibilities. There are a number of them which have been suggested by various member states of taking into account of the losses which exist in Sweden. And were the referring court to reach the conclusion that such proof has been produced, it would be contrary to Article 49 for A to be denied the possibility.
It doesn't really grapple with the question of what is meant by exhausting all possibilities in a situation where there's perhaps a very remote, legally conceivable but practically utterly implausible possibility which would only relate to a small part of the relevant losses. I mean, in common sense terms, that doesn't sound to me like utilising them.
It doesn't, but it does. But I would submit that what the European Court. I mean, remember this is legislation that has been justified.
Yes.
And you're asking the question: is it proportionate?
Yeah.
And so, if there is a possibility, I think what the court is saying, of the losses being used, even if the income is small, that would be enough to prevent. Mean that you would go back to the position that the legislation was justified. Because after all, it has been justified, if you recall, on grounds in the public interest. Which is, this is a very narrow letter. At this point in the chronology, we have Phillips. I was going to come back to Phillips once I just finished looking at the other cases, Phillips and NN. The next case I was going to look at was actually EC Commission in the UK, which is at tab 63.
This is the one you referred to earlier.
Yes. Tab 63 is the Advocate General's opinion, and I think this is the opinion in which Advocate General Cocotte has a long, I was going to say rant, but a long tribe on the Marks and Spencers. But the court didn't pick up on this in this case, so I'm not going to. You can read that at your leisure if you wish.
I'm sorry, which tab is this?
Well, the Advocate General opinion is at tab 63.
Tab 63.
That's where the report starts with. In the bundle, the reports are split into different tabs.
Yes, that's why whenever we look at the judgment.
The judgment is in the second tab.
It's there without the head note, which is really rather.
But it's the same report. It's just a tab has been put in the middle of it.
I've just worked that out.
Yes, it's slightly confusing. I agree. This is the infraction proceedings, as I explained earlier, in relation to the legislation that was introduced post Marks and Spencers.
And just to remind us, that legislation looked at a test at the end of the accounting period in question.
Yes.
To see whether it was there was any possibility of using the losses.
Yes.
Is that right?
That's right. Rather than having to continually look at it for years thereafter. Interestingly, yes, you can see from the court decision, but the court was very unimpressed by the argument that you should be looking at events which happened 5 or 6 or 7 or 8 years later should have an effect on the tax position in year 1 or whatever, which is a consequence of the opposite view, which is that you can go on looking to discover whether the losses can be used years and years later, which is what in fact happened in Marks and Spencer's itself. So the idea of the UK legislation, which we say was in line with the EU authority, ECJ authorities, was that you had to make a decision as to whether these losses could be surrendered at the time when they were being surrendered. And therefore the answer should be clear at that stage, whether there is no possibility of using them. And if that's the case, then you can use them. If that's not the case, then they can't be used. And that's the end of it. Anyway, you can see the judgment. If you just pick it up at paragraph 30, where they say 119.4, which is the provision in question, makes it virtually impossible in practice for resident parent companies to obtain cross-border loss relief. And then paragraph 31 makes the point that the assessments to be made at the end of the time, immediately after the end of the accounting period. The Commission says that made it virtually impossible for group relief to be obtained for losses sustained by a non-resident subsidiary, since in practice it allows the resident parent company to take such losses into account only in 2 situations. One, where the legislation of the member state of resident subsidiary concerned makes no provision for losses to be carried forward. And we will see that the court then says, no, you can't do that anyway. And where, 2, where the subsidiary is put into liquidation before the end of the accounting period in which the loss was sustained. The court says it should be noted, however, the first of those situations referred to by the Commission is irrelevant for the purposes of assessing the proportionality of 1194. It is settled law that losses sustained by a non-resident subsidiary cannot be characterised as definitive, as described in Halsey's case, by dint of the fact that the member state, which the subsidiary is resident, precludes all possibility of losses being carried forward. And that comes from K, and the case law cited there. In such a situation, the member state in which the parent company is resident may not allow cross-border group relief without thereby infringing Article 49. 34. As regards the second situation referred to, it should be noted first that the Commission has not established the truth of its assertion that 1994 requires the non-resident subsidiary to put into liquidation before the end of the accounting period, which the losses are sustained. The assessment as to whether the loss sustained by a non-resident subsidiary may be characterised as definitive must be made by reference to the situation obtaining immediately after the end of the accounting period. It is thus clear from the wording of the provision that it does not in any view impose any requirement for the subsidiary concerned to be wound up before the end of the accounting period in which the losses are sustained. Secondly, we can bear in mind that losses sustained by a non-resident subsidiary may be characterised as definitive, as described in Halsey's case, only if that subsidiary no longer has any income in its member state of residence. So long as that subsidiary continues to be in receipt of even minimal income, there is a possibility that losses sustained may yet be offset by future profits made in the member state in which it is resident. See AOI. So that they've made that a point again. I think you might say that now the settled law, case law of the court. And the point is made in 37 that it's possible to show that there is no possibility at the end of the period, even if the company hasn't been actually put into liquidation at that stage. But it would have had to cease trading and dispose of all its income producing assets.
Okay, so it's slightly wider than winding up.
It's slightly wider, although you have to. I think you probably have to intend to wind it up at that point, but you wouldn't actually have to wind it up, I think is the point that's being made. And these points were repeated. I don't think I need to take you to them, but they're repeated again in the case in TIMAS, which is also in the bundle, bundle 3, tab 66, paragraphs 54 to 55. But it's just a repetition of what was said in this case, so I'm not going to take to that.
Sorry, the paragraph numbers in TMAX 64.
Sorry, they were 54 and 55, tab 66. And then we come to Beveler, which is quite important because my learned friend placed some weight on Beveler. Beveler was a Danish company which was in a group which was controlled by a company called JT, which was also Danish. Beveler had a permanent establishment in Finland which made losses. Beveler said those losses could not be deducted in Finland and applied to deduction from its taxable income in Denmark. Danish law did not allow that unless they'd elected for the Danish joint taxation, international joint taxation scheme. So if we can just take you first to the Advocate General, this is tab 70. And the Advocate General discusses the Marks and Spencer's exception at paragraphs 34 to 39. And if you could just read first paragraph 34 to 36, then we'll pick it up from there. And 37, Advocate General says, in my view, not only is that approach of the court consistent with the criterion of stare decisis, it also observes a sound principle of tax justice, which creates a link between the levying of tax and tax-paying capacity. Tax is levied on the profits of a legal person in a particular year. It's logical that when those profits are calculated, losses incurred by that person should not be excluded, for there will have been a commensurate reduction in the taxpayer's economic capacity, more specifically tax-paying capacity. 38. When in a cross-border context, all the possibilities have been exhausted of taking those losses into account in the state of the subsidiary, that does not mean that the parent company's economic capacity is unaffected. It will definitely have been reduced. That is why the principle underlying the judgment in Marks and Spencer, so this is where he sets up the principle, is that it must be possible for account to be taken of definitive losses somewhere, ensures there is a balance between the tax burden and the actual economic capacity of the taxpayer who's incurred those losses. Appears to me, therefore, the referring court took the correct approach in presuming that the Marks and Spencer exception is a valid starting point for assessing whether Danish law is compatible with EU law. And I think there's this is all in this passage is in fact, yeah, this is in the context of, I think, a discussion of well, it's not clear exactly which section is in. It's not in the proportionality section at this point, but there is something similar later on at paragraphs 58 to 59 in the section on comparability.
It's interesting in 37 to see an Advocate General using the language of stare decisis in relation to
Yes.
TFEU decisions.
Yes.
I rather thought that was absolutely the wrong type of language to use.
I think maybe what he's saying is the language they use is something like the settled case law of court. Isn't it?
Yeah, I suppose that, yes.
And I suppose he's essentially saying that this is no longer something that's up for argument. Really, it's been followed so many times.
Well, and also there was the point that the later case, the Commission against the UK, was a decision of the Grand Chamber.
Yes.
So I suppose that's a sort of way of giving it added force.
Yes, I think Marks and Spencer's might have been as well.
Oh, perhaps they both were.
it
Okay, well, yes.
But anyway, yes, but and who knows? This might have been part of a debate behind the scenes between Advocate Generals about the Marks and Spencer's exception. This may have been aimed at a different audience from. Who knows? But the point I think I'm making here is that the principle underlying Marks and Spencer, the judgment, according to this Advocate General, is that it must be possible for account to be taken of definitive losses somewhere. What he's saying about the tax capacity really, I think, is a rationalisation as to why it's.
Sorry, what is a rationalisation?
Well, where he says in paragraph 37 that this makes sense because there will be a commensurate reduction in the taxpayer's economic capacity. Is a rationalisation. He's saying, well, it's what they've decided is consistent with sound principles of tax justice. But that's not the rationale fact behind the decision I would submit in Marks and Spencer.
So you think the principle is you should be able to take your loss somewhere?
Yes, that's the principle. Yes. In any event, I mean, just staying with this idea of economic capacity. I mean, exactly the same arguments could be made in relation to the current case and Phillips, of course. Because in both of those cases, the result was that the company, the non-resident company, if it were saying that there was no possibility of using the losses, then assuming that company must have lost money. If it said that the rest of the company, leaving aside there's no possibility of taking account of the losses in that, then it must be in the same position as the subsidiaries would be in the Marks and Spencer's type case. Indeed, that company that's much more closely aligned with the PE position than the subsidiaries in Marks and Spencer's. While it's right to say if the subsidiary is losing money, then the parent is in a sense less rich because its subsidiary is worth less. It itself hasn't lost any money. But in our case, a case like ours, then if the company of which there was a foreign PE was not able to use losses, then that would inevitably mean that the company itself, on this reasoning, must have lost economic capacity. And therefore that would be justification for, under the logic of Marks and Spencer's, for allowing the losses to be transferred, but only in that circumstance. So I think what I'm saying is that there's no distinction between a Marks and Spencer's type case and a case like Phillips or like the present case in this regard. And as we shall see in NN, as you'll have seen already, the court doesn't regard there as being any difference. Now the court itself also in Beveler, which is in the next bundle, I'm afraid. The court also deals with the double use of losses. And interesting in this case, the taxpayer didn't rely on double use of losses. Sorry, the member state or the taxing authority didn't rely on double use of losses as a justification. It simply relied on the preservation of the allocation of the power to impose taxes and I think also coherence of the tax system. However, the court itself raised the issue at paragraph 52 where it says, furthermore, the prevention of the risk of double use of losses, while not expressly relied on by the Danish government, is also capable of justifying a restriction of freedom of establishment, such as that at issue in the present case. See to that effect, European Commission in the UK, at paragraph 24.
The way that's expressed suggests it could alone justify.
It does. Yes. It would be also odd to raise it if it wasn't a justification in itself, having already said that it was justified by the balanced allocation of taxing rank. According to the Phillips logic, that would be subsumed in the balanced allocation of taxing rank.
So you wouldn't need to mention it.
You wouldn't need to mention it. Well, you wouldn't do it, particularly when it wasn't raised.
Yeah.
Yes. So can I just then take you to one more case, which is Aure's Holdings, which is at tab 80. In this case, a Dutch company made a loss and then set up a permanent establishment in the Czech Republic. In 2009, the company transferred its place of effective management to the Czech Republic. It remained registered in the Netherlands. It applied to the Czech Republic to carry forward its losses and use them. Now, in fact, the Court of Justice dealt with this case on the grounds of objective comparability, so it didn't go on to look at justification. But I was just going to show you, this is the case where the Advocate General, Court, deals with justification. And if I can just take you to page 1001, which is, the bottom of the page, which says interim conclusion. A accordingly, the justification of the preservation of the balance allocation of the power to impose taxes between member states applies. And then she goes on and over the page to say, the avoidance of double use of losses can also justify the refusal to take losses into account. Justification of avoidance of double use of losses has been recognised by the court since the judgment of Marks and Spencer's. Accordingly, member states must at least have the possibility to be able to prevent a double loss deduction. In fact, extending deduction of losses, particularly losses incurred in the preceding tax year, to foreign losses runs the risk of a double use of losses. And then she says that the risk becomes tangible here because IRA is in a position to carry on economic activity both at the registered office in the Netherlands and at its place of permanent establishment in the Czech Republic. Taking into account the tax losses incurred in the Netherlands in the Czech Republic is therefore subject to the risk of the same losses would also be taken into account again in future in the Netherlands. This holds true especially because provision is made in the Netherlands for a 9-year period for taking losses into account. It's not clear from the Netherlands loss carry forward assessment notice whether the losses had already been taken into account in the Czech Republic. So that does seem to be a different approach we would suggest that the Advocate General is taking in this case.
What's the status of that? I mean, one general question. We're spending an awful lot on an AG opinion in fact in this case, on a topic that wasn't even dealt with by the court.
In this case, yes.
What's the status of that?
Yeah. Well,
it's more, that question is more relevant when we get to Phillips, but
yes. Well, in Phillips, I think one can point out that the Advocate General's approach and reasoning in this case is wholly different from that in Phillips, and of course this case post-dates. This case post-dates NN.
So was this, the challenge in this case was against the use of the losses in the Czech Republic, not to some extent, host state, using that terminology, which you wouldn't use.
I'm not quite sure who would be the host state or the home state in this case. I was going to say something about host state and home state.
Okay, all right. I don't want to get lost in that. My more specific question
there
is
isn't really one.
What we take from this particular AG opinion, and more generally when we get to Phillips, the status.
Well, what you take from the AG opinion here, I would suggest, is that it's consistent with NN. And so it's consistent with my argument that NN has affected a change, certainly from Phillips. It's not the same approach as the AG took in Phillips, because if she'd been taking that approach, in my submission, the reasoning of the Advocate General in Phillips on this was simply it's only in the cases where there's a danger to the balance allocation that you can have a justification, and it's only in that case that you can bring in double use of losses as some kind of make weight to it.
I might be wrong, but I think my lady was asking a slightly more general question, which is what is the status of
an Advocate General opinion? Well, we do have something. Yes, I was going to just take them to the. We do have something in the bundle about that.
We hope they might.
We all take art simultaneously.
We thought that might be important. It's in tabs, volume 7, tab 99, and it's an extract from a book. I don't know exactly how you pronounce it. Matheson's Guide to European Law. And on page 1781 to 1782, you can see a discussion of who the Advocate General is and what the significance is of.
Sorry, all my bundles are self-destructing. Something carrying on from one room to another. So thankful.
Yeah.
Just give me a moment. Please.
Not an ideal type of bundle, I'm afraid.
No. I would put it rather more bluntly.
I haven't quite spun apart, but they're doing that thing of not matching.
Not meeting in the middle. Yeah.
Yes.
For term payments.
Well, I think the lever ones are better. But they're also rather overfull, which is another.
Right.
No, sorry, we'll have the full rant over. Where are we trying to?
Sorry, it's tab 99. It's page 1781.
My page numbers have helpfully disappeared as well. Perhaps I don't know, they seem to come and go intermittently.
Well, if you could get to tab,
Tab
99.
99.
Tab 99 is quite short.
Yes,
so it's,
sorry. Great.
We have a new bundle, 7.
No, thank you. I'm sure over the adjournment between us I'll manage to sort it out.
It's it's the third page on tab 99. And it's the passage beginning, the Advocate General is a member of the court.
This is presumably most correct. That's an odd way of putting it.
Yeah.
Much in the same way as writings of leading legal theorists.
Thank you for the reference.
Doesn't take us all that much further.
I would suggest that there can be circumstances where the Advocate General sets out the reasoning more fully, and the court doesn't simply copy it all out. But if the court comes to the same conclusions as the Advocate General, then you can look at the opinion.
I mean, the court does tend to say if it's specifically endorsing a party. On the other hand, it never ever says, well, we disagree with the AG. That's another of the oddities about it.
No, I think we.
And equally, the AGs don't seem to be at all keen on saying, I'm taking a different line from the one I took in case X 5 years ago.
No, they don't do that. It is true that they do endorse particular paragraphs sometimes but they don't tend to endorse the reasoning.
I always thought the reason for that really was precisely because it is advisory, and what matters is what the court itself says.
Yes.
Having said which, we all tend to look at the AGs just because they're the reasoned product of a single mind.
Yes, but also I think it's justifiable because I think you can assume that the court has read the AG's opinion, which is, as you say, advisory, and if it's following his decision making, then I think it's a reasonable assumption to make that it is following his reasoning, his more detailed reasoning.
Yeah.
So I think that it is legitimate. I think that was the point that was being made in that passage, that although it's not a source of law in itself, and I think we've both been doing it. My learned friend did exactly the same with Phillips by looking at what the Advocate General said as part of the reasoning. I think you have to assume that where the court is very terse, that it's certainly not rejecting the reasoning of an Advocate General who came to exactly the same conclusion as it did.
Does Professor Barnard have anything to say on this topic in her book on the fundamental
No,
freedoms?
I think we yes. Oh right, yes, but there was nothing in the book. No, we didn't find anything. There was something about how the court overrules, but we've got that passage is in the bundle as well.
Thank you.
But I mean, the significance of our raise it's really more of a jury point in many ways, simply showing that the Advocate General.
You say seeing the error of her ways.
I've seen the error of her ways. Perhaps more than that, though. I mean, it is consistent with our argument, which is that NN did shift things, and if she had thought before NN that double use of losses was not an autonomous justification, she couldn't have thought that afterwards. So can I then take you to Phillips? It's in bundle 3. But could I also just show you, while we're looking at this, just for the avoidance of any doubt when we're discussing it, the structure in Phillips. You can find that in the back of the First-tier Tribunal decision, which is in so it's in bundle 6. Right at the back of tab 92. I think it is. Sorry, it's not in the back. It's at 1476, page 1476. It's in the middle of the decision. You'll find there's a chart of the group or the consortium in the Phillips case. It might just be convenient to, if you want to take that out. I don't think we'll need to look at the First-tier Tribunal decision on that. And so, just to be clear, you can see that the UK branch is shown in an oval at the bottom. It's a branch of LGPD Netherlands, which itself has a parent, LGPD Holding, which is also a Dutch company. But the companies to whom the surrender was being made is the taxpayer, which is on the left-hand side of the diagram. And one of the issues you may have seen in Phillips was whether it mattered that the company or companies whose freedom of establishment was being infringed were in fact LGPD Netherlands and or LGPD Holding. Both of those could complain that their freedom of establishment was being infringed. However, the taxpayer who was bringing the tax appeal and relying on this was not, its freedom of establishment had not been infringed. And that was question 4 that went to the European Court in Phillips. And the answer which they gave was essentially, that doesn't matter. Once you establish, once there is an infringement of a freedom of establishment, then anyone who's affected by that can bring proceedings, essentially, and rely on the infringement, because of course it was the taxpayer company who were relying on the infringement of the rights of LGPD Netherlands or LGPD Holding in having the UK legislation set aside. Just while we've got that diagram, it does appear that on my learned friend's argument, if I understand it correctly, that there might have been a difference in this case if the LGPD Netherlands had a parent company in between it and Holdings, which was UK resident. Because then it could be said that the freedom of establishment of that company was being infringed, just as is being argued in the NN case. And then the question would be, well, on my learned friend's thesis, is this a home state case or a host state case? How do you decide which of the many companies whose freedom of establishment might be infringed you take account of in deciding what type of case this is?
But is the answer to that that the taxpayer can effectively take their pick?
The taxpayer can choose.
Effectively take their pick. And the reason why the challenge was taken in the way it was in NN was because they couldn't claim there was a difference in treatment between setting up a foreign PE and setting up a foreign subsidiary. So then they had to find something else.
Yes.
But
of
here
course.
we haven't got an equivalent restriction on surrendering group relief from a UK
in our case there isn't. Sorry, in this case.
No, you're saying you're saying you could find home state restriction or a problem from a home state point of view by interposing a UK company, but that doesn't prevent there also being an issue on these facts where there is a difference between a UK PE and a UK subsidiary.
That's true.
It wasn't
but
in the Danish.
Yeah, but it doesn't turn on whether it's a home state or a host state. Whether you would
that's
categorise it as that.
That's a potentially critical, important issue. But
yeah, well, in my submission, it wouldn't. You could call this a host state case. You could call NN a host state case or a home state case. In fact, all of these cases, the problem is being looked at from the point of view of the branch. Whether the company which has the branch has a Danish parent or any other parent wouldn't matter.
Well, is that right? Because the freedom of establishment being considered in Philips is the ability to set up business in the UK. That presupposes that you've got someone outside the UK wanting to establish inside the UK.
Yes, but that someone could be resident anywhere. I mean, let's take NN. It is pure happenstance that the parent happened to be Danish. It could have been there was a Danish company somewhere else in the group, just as there is with this situation. The parent company could have been a UK company.
It's got to be an EU company.
I mean, EU company, yes.
Yes.
Well, at that time, an EU company.
Yes.
Yes, an Irish company, let's say.
Yeah.
The arguments would be exactly the same, because the problem lies in all of these cases. The problem lies in the surrendering of the losses of the PE to another company which is of the same residence as the PE. That's the important thing in all of these cases. That's where the complaint, and of course the complaint actually arises from the company who's receiving the surrender, because they're the company that has the tax problem. Complaint in the direct sense, I mean, obviously there are different ways you can describe complaints, but so there's no focus on in any of these cases on what the identity is of the company whose freedom of establishment is being infringed.
Sorry, you're saying that in none of these cases is there a focus on...
Well, it doesn't matter. I mean,
no.
Obviously there has to be a company.
Yes.
But that's not important. The important thing is whether there is a difference in treatment, whether there are comparable situations, and that might depend on the tax regime applying and justification and proportionality. But none of this turns on the identity of these companies, of the company who it could be said their freedom is being restricted. As I said, it could be a whole lot of companies potentially. It doesn't matter which one it is. They're not bringing the claims. Claims are being brought by, in this case, by the taxpayer in Phillips. But more importantly, perhaps, when we look at these cases, that nothing turns in NN on that point. Now, it is true, I quite accept, that something does turn on the fact that in NN they had an equivalent provision in relation to Danish subsidiaries of foreign companies. We have to remember that we're talking not just about Danish companies or UK companies, well, my friends seem to be saying, because of course there are provisions about UK companies. Double use of losses is not permitted within UK groups any more than it is here. The point is a very narrow one. It is there anything that stops losses being claimed where they could be surrendered to a foreign parent company? That's the difference between the Danish legislation and the UK legislation. And it's true that because of that, in NN, there wasn't any different treatment at that level, because they were both treated in the same way. The losses were denied, and you had to look at a different difference of treatment, which you've seen. We'll come back to, and all of that has some relevance to objective comparability. But in my submission, none of this is relevant to the question of justification. So then, yes, can I take you to Phillips? It's tab 57. And then I shall come back to objective comparability when I deal with our appeal. So can I just take you in the Advocate General's opinion to 689, the justification, which begins at paragraph 39. And she starts with the uncertainty which clearly exists over the interpretation of the judgment in Marks and Spencer's. And then she goes on in paragraph 41 to refer to the two cases that I mentioned before. Proceedings by OIAA. In my opinion, I stated that preserving the allocation of the power to impose taxes is at the heart of these three elements. In the judgment in that case, the court accordingly recognised that a justification is possible through the two elements of safeguarding the allocation of the power to tax between member states and the need to prevent tax avoidance. I would submit that the second sentence doesn't follow from the first. It may be true that in her opinion in that case, the Advocate General stated that preserving the allocation of the power to impose taxes is at the heart of the element. But the reason that wasn't the reason that the court recognised those two justifications. It recognised those two justifications, as we've seen, because those were the appropriate justifications that applied.
So you'd quarrel with the adverb accordingly in the second sentence?
I would quarrel accordingly, yes.
And that's what lies behind, is this what you would say, the slightly mystifying focus on the preservation of power to impose taxes as being the organising principle in this area?
Yes, I think But that's clearly this Advocate General took that view.
Yes,
No doubt about it.
yes, but I see that you're saying it doesn't actually follow from IAA
Or Lidl.
or Little.
She then says something in Lidl, it also accepted a justification solely on the basis of the allocation of the power to tax between the member states and the danger of the same losses will be taken out twice. That's because, as we've seen, those were the appropriate justifications that were applicable in that case. Then she says, therefore, it's clear that the crucial factor for the justification is ultimately that national legislation pursues the objective of preserving the allocation of the power to tax. But that seems to be derived from a very small sample of cases.
And a slightly selective reading of them.
Which happen to, it's true, have those two justifications. If she'd found a case which had tax avoidance and preventing double use of losses, I don't know what she'd have said about that. It could be a case where the balanced allocation of taxing rights wasn't relevant, but it applied. But was, I'm just imagining a case where the justifications were tax avoidance and the double use of losses. That could easily have been a case which could have arisen. So then she says, against this background, the objectives of preventing the double use of losses and tax avoidance do not constitute an end in themselves, but are relevant only insofar as they serve to preserve the application of the power to tax between member states. And accordingly, the court examined and accepted this justification most recently in National Grid Indus, simply in itself, i.e. without recourse to the aspects of preventing the double use of losses or tax avoidance.
So what?
So what? Well, yes, the reason was that those were not relevant in that case. That was a case about a company moving its residents from one country to another. And as is quite common, there is a provision, quite commonly states have a provision which taxes the company on its gains that are which haven't been realised at the time when it moves residents. And the question was whether that system was contrary to freedom of establishment. And the justifications that were put forward there were the only justification that was put forward was the right to preserve the balanced allocation of the power to tax, because the argument was that the gains had accrued while the company was resident in that state, and therefore if you didn't allow the country to tax it when it ceased to be resident, then they would lose that taxing right. In fact, the court held that although it was justified, it wasn't proportionate. I think in that case to have the tax all crystallised at that point. You were permitted to have a system where you were able to collect it later, perhaps when the assets were sold or whatever. Sorry.
Go on.
But in principle, the states were entitled to preserve their right to tax that gain that accrued while the company was resident.
So again, the accordingly and at the beginning of the final sentence of 42.
I would say is
Erode accordingly.
Yeah. And then she says, this finding is particularly important in the present case. As I will show below, preserving the allocation of the power to tax does not justify the restriction of the freedom of establishment issue, even though it is intended to prevent the double use of losses. And I would absolutely agree that the reason that the allocation of taxing rights is not an issue in a case like this is, as my learned friend rightly pointed out, that we're dealing entirely with UK losses being surrendered to a UK company. So if you were to allow that to take place, you would not be upsetting the balanced allocation of taxing rights in any way. You would simply be essentially treating the permanent establishment as part of the group with the UK company, part of one entity, and consolidating their results. As opposed to a situation like Marks and Spencer's, where you're actually bringing in losses from another country, which accrued while they were French company. So, of course, she's quite right, and the court also said this, that the allocation of the power to tax is not an issue in this case. So and she says, having quite rightly reasoned about that in paragraphs up to paragraph 49, she then says in paragraph 50, it's irrelevant to safeguard the power of taxation of the United Kingdom whether the losses to be surrendered can also be taken into account in the Netherlands. Taking the losses into account there has no bearing on the power of the taxation enjoyed by the United Kingdom. That power can be impaired only if losses which are incurred within the scope of the exclusive power of taxation of another member state are taken into account. Such losses would reduce the tax revenue of the United Kingdom, even though the profits from the activity cannot be taxed. So she is then linking it. She is saying, well, a double use of losses doesn't matter if it's a double use of losses that doesn't concern the member state. Now, the difficulty with all this, of course, from the beginning is it's difficult to see how there'd ever be a double use of losses justification which wouldn't involve the losses being used in two different states. And that's exactly the position in Marks and Spencer's. The losses are being used, the double use of losses is once in France and once in the UK.
Oh.
That's inevitably going to be the case. That's what all these cases are about. No state would allow the double use of losses within its own state, unless it made a mistake in its tax legislation. But that would never be allowed.
And it wouldn't be subject to a freedom of establishment challenge.
No, well, yes, perhaps. Well, it might be.
It might be.
Unless the mistake wasn't extended.
It might be if it was a UK branch of a foreign company.
Yeah, exactly.
And somehow the UK legislation allowed it to use its losses twice. But that's not the kind of problem that we're dealing with in these cases. The problem we're dealing with in all of these cases where they're talking about double use of losses is that the losses are going to be used once in one state and once in another state. So if the Advocate General is right about this, really all the mentions of double use of losses by the European Court, going back to Marks and Spencer's, must be wrong or misconceived. The European Court wasn't have understood that really double use of losses wasn't a justification that could be relevant.
And the Curia Act, per incuria.
Per incuria, yes. And then in paragraph 52, she says, in the present case, the profits from the domestic activity of the permanent establishment of LGPD Netherlands are subject to the power of taxation of the United Kingdom. Use of the losses from that activity cannot therefore be refused by relying on the preservation of the allocation of the power of taxation. As the court found little, that justification is intended only to safeguard symmetry between the right to tax profits and the right to deduct losses. Or, as the UK government put it, profits and losses are two sides of the same coin. This position likewise cannot be countered by the above-mentioned argument put forward by the United Kingdom to the effect that a domestic company, a branch of a foreign company, are not in an objectively comparable situation as regards their taxation. I think argument I'd like to consider once again here. And then she goes on to talk about that. And then she comes back to the double use of losses at the bottom of the page at 58. It must still be examined whether the objective of preventing the double use of losses can constitute an autonomous justification. And she then goes on to say in paragraph 63, furthermore, the current international delimitation of taxation laws may even require double use of losses. This is the case whenever the income is taken into account for tax purposes by two different states. If double taxation of the income of a foreign permanent establishment is counted through the credit procedure in the company's home state, its income will be subject to tax both in the state in which the permanent establishment is situated and in the company's home state. the double use of losses in such a case is a logical consequence of the double significance of one source of income. Well, that's correct, but misses the point. This is correct, and it applies in relation to carry forward of losses, as we have attempted to demonstrate. You may have seen in the annex to our skeleton argument, we give an example which demonstrates that where you're carrying forward a loss of a permanent establishment, it is in fact necessary to make use of the losses twice.
Yes, in a credit.
Because of the credit system.
In a credit system.
In a credit system, exactly, yeah. Yeah, that's correct, in a credit system. However, it's wholly different where the losses are being group relieved to a completely separate company in the group. Because there you don't have the same circumstance. A similar point is made. I may come back to that tomorrow. In the BEPS, one of the BEPS documents, where they're talking about a hybrid solution, and they make the point that there isn't a problem where you have income which is dual taken into account. The same income is taken into account by two entities, for instance, the company and the branch. But there is a problem where it's not, where the income that's being relieved is somewhere else. So this is correct, but only in a limited extent, not in relation to the circumstances in the Phillips case. In fact,
underlying this is you're saying the Advocate General doesn't really understand what the provision in issue is doing in this case. Well, that may be what you're saying, because by referring specifically to this point, she hasn't picked up that nuance.
Yes.
That what she says breaks down when you add group relief.
Yes. I think that's right. It may just be a weakness in the European court system, of course, because you never get a chance to deal with these points.
Yeah.
When they appear in the Advocate General's opinion, because you're not allowed to comment on the Advocate General's
nevertheless, going back to the point earlier, I think what we're interested in is what that means for the courts.
Yeah, certainly. Yeah. But can I just finish on the Advocate General? So she then says, against this background, the prevention of the double use of losses cannot be an end in itself. The aspect of prevention of the double use of losses understood so far in the case law solely concerns the question whether a member state has the right, in the context of the balanced allocation of the powers of taxation, not to take into account a loss in the taxation of its taxpayer. That right may stem from the fact that the loss is taken into account in another member state under whose fiscal jurisdiction the taxation of the profits of the relevant activity falls. The loss is attributed to that other member state because it taxes the relevant profits. Use in a further member state which does not tax the profits would possibly be double. So I think she's limiting the double use of losses to this kind of circumstance. The use of the losses of a permanent establishment in the United Kingdom whose profits are taxed in the United Kingdom is therefore not double but single. This is also provided for in principle by United Kingdom laws insofar as the losses of the permanent establishment may be transferred to earlier or subsequent tax periods. I'm not sure whether she picked up on the fact that that is actually a necessary part of the system. When she was talking about the double use of losses earlier, she may not have had in mind, in fact, the carry forward and carry back examples which we gave. I think the Advocate General thinks that the United Kingdom ought to have prevented losses being carried forward and carried back. But it's quite clear from what she's saying here when she talks about...
Well, yes, that's effectively what she says at 66, isn't it? Because she's saying you're not being consistent.
Yes. Exactly, that's her point. I was going to come on to that, my lady. But where she's talking about them not being double but single, she is focusing entirely on the position in the UK, my submission, and saying, well, the losses are only being used once in the UK. And essentially, I think that basically the thinking behind all of this is, well, unless the UK has a problem, the UK shouldn't be doing something about it. In other words, we're not the world, we're not the international policeman. The double use of losses here doesn't affect the UK because the losses are only used once in the UK. But the point which we'll see later on in NN is a much broader policy point, which is there is a general problem.
Yeah, with double use of
with
losses
this.
in different jurisdictions.
Exactly.
Yeah.
And the only way to fight it, absent a general, absent some general provisions that apply internationally, is for countries to prevent the double use of losses. Yeah, but if we just carry on to 66, she then says, for this reason, even if the prevention of double use of losses were to be recognised as an autonomous justification, the tax rules in the United Kingdom would not in any case be capable of preventing double use. As the court has pointed out, national legislation is appropriate for ensuring attainment of the objective pursued only if it genuinely reflects a concern to attain it in a consistent and systematic manner. Now, in fact, the test, as I will show you, possibly tomorrow, in the case law, is that it must not be manifestly inappropriate. The court recognises that in this kind of area, member states have a margin of appreciation, it might be called. But in any event, she then says this is clearly not the case in the United Kingdom with regard to the double use of losses of UK resident permanent establishments of foreign companies. The condition applies only to group relief. However, carrying losses forward and back over different tax periods is permitted for permanent establishments situated in the United Kingdom, irrespective of whether such losses are also taken into account in the company's member state. The tax rules on the deduction of losses do not therefore, on the whole, pursue in a consistent manner the objective of preventing the double use of losses, and that's where we say she's simply wrong about that. That it isn't necessary, in fact it would be inappropriate to restrict double use of losses on carry forwards and carry back. And of course, just in case it needs to be said, losses which are carried forward cannot be group relieved thereafter. They can only be set against the profits of the company itself, or the permanent establishment itself. So the court, we then look at what the court said on this question. And it begins its justification passage at 702, paragraph 21. And it makes the point at 25 that in a situation such as that in the main proceedings, the power of the host member state on whose territory the economic activity giving rise to the losses of the permanent establishment is carried out to impose taxes is not at all affected by the possibility of transferring by group relief into a resident company the losses sustained by a permanent establishment situated in the territory. And that's distinguished from a case where it could be used, it would be linked for that reason to the other member state's power to impose taxes. So where another member state's losses could be used, that's a sort of Marks and Spencer situation. So the court is making the point clearly that there is no danger to the balanced allocation of taxing rights. It then says, 27, it follows that the host member state on whose territory the economic activity giving rise to the losses of the permanent establishment is carried out cannot, in a situation such as that in issue in the main proceedings, use the objective of preserving the allocation of the power to impose taxes between the member states as justification for the fact that under its national legislation, the possibility of transferring by means of group relief to a resident company losses sustained by the PE of that member state in that member state of a non-resident company is subject to a condition that these losses cannot be used for the purposes of foreign taxation. or the transfer of losses sustained in that member state by a resident company is not subject to an equivalent condition. And then we come on to double use of losses. As regards, secondly, the objective of preventing the double use of losses, it must be observed that even if such a ground considered independently could be relied on, it cannot in any event be relied on in circumstances such as those in the main proceedings to justify the national legislation of the host member state. The dispute in the main proceedings concerns the question of whether the host member state may impose certain conditions on the possibility of transferring for group relief to a resident company losses sustained by the permanent establishment situated in that member state of a non-resident company, while the transfer of losses sustained in that member state by a resident company is not subject to an equivalent condition. In such circumstances, the risk that those losses may be used both in the host member state, where the permanent establishment is situated, and also in the member state where the non-resident company is its seat, has no effect on the power of the member state where the permanent establishment is situated to impose taxes. So we would say that they are adopting the same reasoning as the Advocate General, and then they go on to make that clear. As observed by the Advocate General in point 49 of her opinion, the losses transferred by the permanent establishment in the United Kingdom of the Netherlands company to Philips Electronics, which is a resident company established in the UK, can be linked in any event to the United Kingdom's power to impose taxes. That power is not at all impaired by the fact that the losses transferred might also, in appropriate circumstances, be used in the Netherlands. So they then say, in circumstances as those in the main proceedings, the objective of preventing the risk of double use of losses cannot, as such, allow the member state in which the permanent establishment is situated to exclude the use of losses on the ground that those losses may also be used in the member state in which the non-resident company has its seat. The host member state in whose territory the permanent establishment is situated therefore cannot, in order to justify its legislation in a situation such as that in the main proceedings, and in any event, plead as an independent justification the risk of the double use of losses. So, although the court starts by saying in 28, even if such a ground considered independently could be relied on, it is difficult to see on the basis of the reasoning which it then comes into whether how that could ever be, because it seems to be then saying, well, it cannot rely on this unless the situation is such as to put at risk, impair the UK's right to levy taxation. In other words, to endanger the balanced allocation of taxing rights. So it does seem to be ruling out the possibility in this passage that double use of losses could ever be an autonomous justification. It always has to be in a situation where there would be another justification. So what we would say about this is, well, on its own terms, it is inconsistent with the other case law, and particularly when we come to NN. None of the other case law that we've seen, both before and after this case, suggests that double use of losses can only be relevant where there is a breach of the balanced allocation of taxing rights. This is the only case we would submit that says that. As regards the Advocate General's opinion, insofar as it has been adopted by the court, we would say it's obviously relevant to look at the reasoning there. I've already made submissions about the reasoning of the Advocate General. So we would say, and I think my learned friend agrees with this, that they are essentially adopting the reasoning of the Advocate General in this.
Do you differ on how much they're adopting, though?
How much they're adopting?
Yes, the AG 49 at SAC.
Yes,
point.
well, what's not clear is that they don't refer to the separate point which the Advocate General makes, which we also see is wrong in paragraph 66 and 67.
So that's my point. You say they do not endorse 66 and 67.
They don't go down that line at all. No, they don't need to, because they say, because remember it begins even if the prevention of double use of losses were to be recognised as an autonomous justification. It's quite clear that the court has not recognised it as an autonomous justification. So.
Or maybe it's just decided not to deal with that point because it considers that the point it goes on to make is a knockout point.
Yes, it's already, it's already done. That's right. Or maybe it thinks it's wrong.
Yeah.
Who knows? We don't know.
We don't know. No.
No. But it certainly hasn't.
Pregnant with ambiguity.
It isn't necessary as part of its reasoning. So it's not necessary to adopt that if you are adopting the Advocate General's opinion. And in fact, it's not something that's. I don't think it's even sort of presaged in any way in the judgment. In that this does depend on a particular point about carrying forward losses, which.
There's no discussion of that.
I don't think there's any discussion. Certainly not that is a problem anywhere. I think there is, yes. There certainly is mention of the fact that losses of a resident company can be, I think, utilised. But in any event, whether that's adopted or not, I don't think is not relevant because of what we say about NN. It's also rather strange to be attributing the court with a point that's patently wrong. It doesn't make it right for the court to state it. In a sense, it's not a question for the court. It does depend on the particular tax regime in the UK. The court is supposed to be interpreting the treaty provisions and telling you how they operate.
Well, it doesn't prevent it from giving.
It certainly
does.
Sometimes
Intended to be helpful hints in a number of cases.
It does, yes.
How the reasoning should be applied to the facts.
But you can't say that a decision, something that it says, which is wrong as a matter of domestic law, would be binding on this court. In fact, I think there was a case, wasn't there, in the Supreme Court, where the Supreme Court refused to follow a European court decision because it
I've forgotten what it was called. But
yes, got the law wrong in the UK. So that's Phillips, and then I was going to take you on to NN. I don't know whether this is. You'd like to go to NN now or morning? We're well ahead of time, I think.
Do you think so?
It's entirely up to.
The case is listed for a day and a half, is it?
2 days.
Oh, it's 2 days.
This is for 2
Oh,
days.
this is for 2 days. Oh, I see. Oh, well, we probably are. What's your best estimate of when we're likely to finish if we were to stop now?
Oh.
Put you on the spot. I mean, we will finish tomorrow.
Shaved half an hour off.
Yes, exactly. My learned friend took half an hour off it already.
Yes.
And already our time estimates were about half an hour less than the total court time. So
Right.
I think we're well
You
ahead.
think you're well on target, so if
Yeah.
we were to rise now,
Yeah.
we wouldn't be in difficulty tomorrow.
No.
No. All right. Well, that sounds like a convenient moment to stop then. Thanks very much. So, it's all right to start again at 10:30. We're confident we'll finish. All right. Let's do that then.